This is Kerstin Henze from our Tampa location of K. Bender Rembaum. Kerstin, take it away, my friend.
Thanks, Jeff. Thank you so much. That was so sweet. Hello, everyone. Good morning. Again, I'm attorney Kerstin Henze with the law firm of K. Bender Rembaum. I'm one of the partners and managing attorney of the West Coast office for the firm, which is located in Tampa. We do have, multiple locations. For those of you who are not familiar with the firm, our main office is located in South Florida, in Pompano Beach, Florida. But we also have offices in Palm Beach Gardens as well as in the Orlando area. We are a community association full service law firm. So that means that we exclusively represent condominium, homeowners, and cooperative associations. As well as, in addition to providing day-to-day guidance with your management and operations of your association, we also assist clients with collections foreclosures in-house, as well as dispute resolution. So that would be your mediation, your arbitration, and your litigation. Okay. I've been with the firm since 2010 and practicing law. I guess 17 years, close to 18 years. All right, so let's see. I'm gonna share my screen and I'm gonna post some slides here. I'm not gonna go through them verbatim.
And while Kirsten's getting that up, I see a couple of you came in slightly after my announcements. Again, this is the certification. If you took this version of the certification class, which would be from September 2024 to now, this version, you do not need to take it again because this will not count as CEU. You will need the CEU classes that I mentioned earlier. We have some on the calendar now for next week, and we'll have several more for August and September populating on the calendar today and tomorrow. So I hope that makes sense and clears it up for everybody. I see Kirsten's ready. Back to you.
Great, thank you. All right, so we're going to talk about the basics of operating, managing a homeowner association. So the topics that are covered here are topics that are mandated, that were required by the division. Okay, so let's start with why are we here? I'm going to go through the slides and then I will leave some time at the end of the webinar to go through some questions, okay? There is no, first of all, I want to clarify, there is no statutory requirement for this particular course to be 4 hours. We typically, it typically takes about 2 hours, a little less, a little more. So I'm hoping that we can complete this webinar in less than 2 hours. All right, but why are you here? You're here because the Department of Business and Professional Regulations, the DBPR, says that you have to take a division-approved education board certification class. And if you're a newly elected director, you have to take this course within 90 days of being elected or appointed to the board. Okay. The certification of completion that you will be receiving when you've completed this class is valid for up to 4 years. And then a director has to complete this education, this board certification class, at least every 4 years. Okay, so as long as you've served uninterrupted, you're good for 4 years, and then you'll have to redo it again. So if you were on the board prior to the date that this statute took effect, which was July 1st of 2024, then you have up to 4 years to complete this board certification class. Okay. Now, this board certification class has to cover several topics: financial literacy and transparency, record keeping, levying of fines, as well as notice and meeting requirements. And we'll go through all of that in this class. Now, a director who does not timely complete this board certification class is suspended from the board until he or she complies with the requirement. And the board can then temporarily fill that vacancy during the period of suspension. Now, once you've completed your certification, you will provide a copy to either your management team or your secretary who maintains the official records for the association. And the association then has to retain a copy of the certificate for 5 years after the director's election. However, the statute does say that the failure to have the written certification or educational certificate on file does not affect the validity of any board action. Now, once you've completed your board certification class, okay, there is a requirement for you to complete continuing education classes. And how many hours of continuing education courses you need to complete will depend on the size of your community. So, if you're in a community with fewer than 2,500 parcels, then you have to complete at least 4 hours of continuing education annually, so each year. If, however, you're in a community that has 2,500 parcels or more, then each year you have to complete at least 8 hours of continuing education. So as Jeff mentioned, we have been approved to teach continuing education courses, and we have a number of those, and they range from 1 hour to 2 hours. So I encourage you to go on our website and look at the calendar and see what courses we have coming up in the next several months and sign up for those courses. And they're all free of charge, complimentary. All right, let's move on. Chapter 720, the purpose, the application, and conflicts. All right, so first things first. For community associations, homeowners associations governed they're governed under Chapter 720 of the Florida statute. They're also governed under Chapter 617 of the Florida statute. And Chapter 617 is the statute that governs not-for-profit corporations. So as you may be aware, your association is a corporation. It is an entity. It is registered with the Division of Corporation. And so it is also governed by Chapter 617 of the Florida statute. Now, which version of Chapter 720 will apply to your community? Well, as you may be aware, typically, every year the legislature makes some changes to Florida statutes, 720 and then, 718 for condominium associations. So the change, whether or not certain changes to the statute will apply to the community will depend on whether you have what is known as Kaufman language. Okay, Kaufman language basically means, and typically Kaufman language, well, first of all, Kaufman language refers to words as amended from time to time that you will typically find referenced after Chapter 720. In your Declaration of Covenants. So typically within the first few pages of your Declaration of Covenants, you might have a statement to the effect of that the community, the association is governed under Chapter 720 of the Florida statute, and then it might have the words as amended from time to time. So if you have language that, if you have the amended from time to time language, that means that substantive changes to the Florida statute will retroactively apply to your community. Okay, now substantive changes are changes that affect the vested rights of owners. So we'll talk about those throughout the webinar, but a good example of a substantive change is the change that went into effect last year regarding the parking of commercial vehicles and trucks in the community. So the legislature changed 720 to now say that an association cannot prohibit a commercial vehicle from parking in the community unless, of course, it meets the definition of this commercial vehicle. And so whether or not that particular change will apply to your community will depend on whether or not you have Kaufman language. If you do not have Kaufman language in your declaration, then the constitutional argument that can be made is that, well, the changes do not apply retroactively, and the law that applies to you would be the law that took effect when the declaration was originally recorded. Okay, and that argument is premised on a very basic principle in the law that the legislature can't just come in and make changes to laws that impair existing contractual rights, right? And so your declaration is essentially a contract between the owners and the association, right? And so the legislature can't just come in and make changes to the statute that affect certain provisions and restrictions that are already contained in your declaration. Okay, so this is a little bit more of a complicated a concept, and I would encourage you that if you have any questions as to whether or not certain changes in the statute apply to your community, that you seek legal guidance for further clarification. Now, there are certain changes to the statute that are considered procedural. And actually, we've provided some definitions here for procedural and substantive changes to the law. And procedural laws provide the means and methods for the application and enforcement of existing duties and rights. So, for example, when the statute provides certain provisions regarding elections, right? And typically any changes to that would be procedural changes. Well, procedural changes to the statute will apply to your community regardless of whether or not you have Kaufman language, okay? Now, as a practical tip, if you want to amend your declaration to either have Kaufman language or remove Kaufman language, that's certainly an option, but I encourage you to speak with legal counsel whether or not that is beneficial for your community, okay? All right. So now in terms of conflicts between Chapter 617 and 720, if there is a conflict between any provision in 617 and Chapter 720, then the provisions in Chapter 720 is what will control to the extent that there's nothing specifically covered in 617, okay, that is covered in 720, okay. All right. And now you also have what are referred to as your governing documents, right? And your governing documents, went too fast. Your governing documents consist of 3 specific documents. You have your Declaration of Covenants, your Articles of Incorporation, and then you have bylaws. And each set of document contains certain types of provisions. So your declaration, as I mentioned earlier, is essentially the contract between the association and the owners that buy into the community. It is the document that's going to contain your use restrictions, which you can or cannot do. For example, can you park a truck in your community? Can you have pets? Are buyers and tenants required to go through an approval process? Okay, that's in the declaration. Your articles of incorporation and your bylaws are more of your the corporate documents that set the corporate structure of your association. So who qualifies as members of the association, who qualifies as a director. It will outline how your elections are supposed to be conducted, who are your officers, so forth and so on. The articles of incorporation are typically filed with a division of corporation in Tallahassee, as well as recorded with the bylaws in the public records. If there is a conflict, typically the declaration is what is going to supersede. And then any conflicts between the articles and the articles will control, with the bylaws being the last document in the hierarchy. All right, let's move on to membership meetings. So when I talk about membership meetings, I'm talking about meetings of the owners. Okay. So within the concept of membership meetings, there are 2 sort of smaller umbrellas. Okay. So if nothing else, you will have one membership meeting each year, which is going to be your annual membership meeting. Okay. And that is it is the meeting at which you're going to have your election. Okay, and you might have other agenda items up for discussion at that meeting, but it is the annual meeting is the meeting at which you're going to have your election. Any other meeting that you will have of the members throughout the year will be called a special membership meeting. Now, you only need to conduct a membership meeting if you're going to have owners vote on anything, right? So if you're just reporting, committee reports, the president's reports, whatnot, if you're just reporting the state of the affairs of the association, you wouldn't need to call a special membership meeting, right? You're just reporting. That would be more appropriate for a board meeting, okay? Board meetings, which we'll talk about momentarily, are meetings at which the board votes, okay? So for special membership meetings will be called when at least 10% of the voting interest petitions the association to call such a meeting, unless, of course, your governing documents provide for a different percentage. Special membership meeting can also be called by the board. For example, if the board is looking to amend the governing documents, typically that's something that requires a membership vote. You as a board might call a special membership meeting to get owners' approval on the amendments, okay? Now, for annual membership meetings, unless the governing documents require otherwise, notice of the annual meeting does not need to include the agenda. However, we encourage for any membership and definitely a board meeting to include agenda items. Special membership meetings have to include agenda items, right? The purpose of the meeting and what you will be discussing at the meeting. All notices have to, of course, include a date, a time, and then the location of the meeting. And unless the bylaws provide otherwise, okay, if they do not provide a procedure for providing notice to the members, the association has to either mail, deliver, or electronically transmit notices of membership meetings at least 14 days before the meeting. And then evidence of compliance with this 14-day requirement has to be done by an affidavit executed by the person that's provided the notice. And typically that could be your property manager or the secretary. Notices have to be mailed or delivered to the address that's identified as the owner's mailing address in the official records of the association. Or you can electronically transmit notices via email to owners who have consented to receiving notices via email. So if you want to be able to email notices and membership packages to the membership, make sure that you do have a written consent from that owner, which can be sent electronically. Okay, consenting for you to email official notifications to the owner. Now, the email addresses, if an owner does consent to receiving notices electronically, the email address and the fax numbers provided by the members receiving the notice must be removed from the association records when the member revokes consent to receiving electronic transmission. So, if an owner does consent to receiving notices electronically, those email addresses do become accessible to other owners. So if you get a request from an owner for the email address of owners in the community, those are accessible only for those owners who have consented to receiving notices electronically. If an owner later revokes that consent, well, those email addresses for those particular owners are no longer become accessible. Okay. Now, electronic transmission may not be used as a method of giving notice of a meeting called in whole or in part for a special meeting of the members to recall a director. So cannot use electronic notices to recall a director. So in addition to sending notices the way that I've just described in the prior slides, the board also has the option of adopting a procedure for conspicuously posting and broadcasting notices and the agenda on a closed-circuit cable television system that serves the association. So you have that option. Obviously, this would apply to those communities who do have bulk service contracts, okay? If you don't have such bulk service contracts, don't worry about it. This is just an alternative option. Now, by January 1st of 2025, so this date has now come already, the association, an association that has 100 or more parcels is required to post notice and agenda on each of each membership meeting at least 14 days prior to the meeting. Okay, so by now, if you are a community that has 100 or more parcels and you fall in this threshold, you should have already set up a website, an association website. Okay, if you have an association website, then you're also, in addition to providing notices, the other methods that we've discussed with mailing, emailing, and posting of the notice, you also have to post that notice on the website. Now, in addition to posting that notice on the website, you also have to post any document that is associated with that vote, and it has to be posted at least 7 days prior to the meeting. So, for example, if you're having owners vote on amendments to your governing documents, then copy of those amendments would also have to be posted with the notice and agenda of that meeting. Now, owners have the right not only to attend membership meetings, but also to speak at the meetings with reference to all items open for discussion and all items included on the agenda. And notwithstanding anything that you might have set forth in your governing documents, an owner has the right to speak on any item for at least 3 minutes. Now, the board can still adopt and encourage you to adopt written reasonable rules governing the frequency, duration, and other manner of owner statements. You just can't adopt a rule that gives owners less time to speak on designated agenda items at the meeting, okay? Membership meetings must also be held at a location that's accessible to physically handicapped persons if it is requested by a physically handicapped person. And any owner may also tape or videotape membership meetings. And the board can also adopt reasonable rules governing the taping of meetings. Now, with regard to quorum requirement, unless you have a lower number set forth in your bylaws, quorum for an HOA will constitute up 30% of the total voting interest. So you're going to have to look at your bylaws and see what it provides for quorum. If it has a lower quorum requirement, for example, 10% of the voting interest or 20%, then you go with that. If, for example, your bylaws are older and they might include a quorum to consist of a majority of the owners, well, then in that case, you default to what the statute provides, which is 30% of your voting interest. In terms of decisions made by the owners, unless otherwise required by law or in the governing documents, decisions that require vote of the members must be made by concurrence of at least a majority of the voting interest that is present in person or by proxy at a meeting at which quorum has been attained. So it's not a majority of the entire voting interest. So let's say you have a community of 100 parcels. Each parcel is entitled to 1 vote per parcel. We're not talking about a majority of the 100, which would be 50% plus 1. We're talking about a majority of those owners who attend the meeting and vote, assuming that at least a quorum of the owners is present. Okay. Proxies. So unless otherwise provided, either in the statute or in your governing documents, members typically have the right to vote in person or by proxy. Okay. In order to be valid, the proxy has to be dated, include the date, time, and the location of the meeting, and it has to be signed by the authorized person who can execute proxies. So typically either the owner or the voting member who's authorized to vote on behalf of the parcel, who can then execute the proxy. Proxies are typically only effective for the specific meeting for which it was originally given. However, the proxy is also good for 90 days from that original meeting. So the benefit of this is that if, let's say, you're presenting owners with amendments to vote on, and let's say the meeting is held, August 1st, and on that day you count your proxies, you count your ballots, and you don't have enough votes necessary to pass the amendment. You have the option to recess and reconvene the meeting for as many times as necessary up to that 90th day. And then in that time, knock on doors, send out email blasts, anything to get the necessary votes. Okay, so you have 90 days from the original date of the meeting to get those votes. There is a process to recess and reconvene the membership meeting, and so if that's something that you're interested in, then I encourage you to speak with your legal counsel about the specific steps for you to properly recess and reconvene a membership meeting. Now, do note that proxies are revocable at any time by the person who executes it. And a proxy holder may also appoint in writing a substitute proxy to act on his or her place if the original proxy provides the right to do so. A copy of an original proxy can be used if it is a complete reproduction of an entire proxy. So typically, yes, you can email your proxy to your property manager or to a board member in advance of the vote. That would be fine. All right, electronic voting. That's different from, electronic transmission of notices. Electronic voting refers to the ability of owners to vote electronically via a platform that allows for electronic votes. So, the board can institute and allow owners to vote electronically. And typically that only requires a board vote. So there's a misconception that owners have to approve e-voting system in the community. That is not accurate. The board can exercise business judgment and adopt e-voting process for the community. Typically that's done at a board meeting. And the notice of the meeting at which the board is going to approve electronic voting has to be provided at least 14 days prior to the meeting. Okay, and it's at that meeting that you will then adopt a board resolution instituting electronic voting. Now, the statute provides what this resolution has to include, and I've set out here some bullet points of what the statute requires. We, the firm, we've assisted many clients in adopting electronic voting for their community and can certainly assist in preparing these resolutions. So at a minimum, the resolution has to provide that members will receive notice of the opportunity to vote through an online voting system, and then establish reasonable procedures and deadlines for members to consent to electronic voting, as well as reasonable procedures and deadlines for members to opt out of online voting. So the second part to instituting electronic voting is once the board adopts and authorizes e-voting, owners have to opt into the system. Okay, so they have to affirmatively consent to opting into the system in writing, and the consent can also be emailed, so that's okay. And as long as the owner has opted into the system, they can vote electronically. The owner also has the option to opt out of the system at any point. Okay, and so your resolution has to provide for procedure and timeframes within which owners can opt in and out of the system. Now, an owner that votes electronically is counted as being in attendance at the meeting for purposes of determining quorum. So as long as the owner casts that vote electronically, they don't have to then physically appear at the meeting or submit a proxy in order for their attendance to constitute towards quorum. Okay, their e-vote counts for that. Now, the statute does outline what the voting platform, the the requirements that the voting platform has to meet. I'm not going to go through them, but we've put them here on this slide for you to take a look. There are certainly a number of e-voting platforms out there. I'm sure they all comply with the statute, or hopefully they do. So certainly, if you're interested in instituting e-voting, and when you seek out, vendors and you vet them, just make sure that in your interview, you check off these items here that their system does comply with. All right, so let's move on to elections of HOAs. So a vacancy on the board that's caused by the expiration of a director's term must be filled by election. Okay, so we're not talking about vacancies that happen throughout the year. This is a vacancy that's created by the director's term expiring that has to be filled at the election. And remember, your election is going to be held in conjunction with your annual meeting. Now, very important to note here, the third bullet point. Elections have to be conducted in accordance with the procedure set forth in the governing documents. So unlike condominiums that are that typically have one statutory election process, right, that's set out in the statute and in the administrative code, with HOAs, you have to conduct your elections in the manner that's provided in your bylaws. Okay, so I say this because, I've seen it time and time again where, a board conducts elections in a way that they feel they should, and perhaps have adopted some kind of rule or a policy of how they wish to conduct elections, which is not in accordance with what is provided in your bylaws. And so if you're conducting your elections in a way that's not in accordance with your bylaws, you subject the election to a successful legal challenge, right? If an owner ends up challenging the election results. And so the takeaway here is take a look at your governing document, take a look at your bylaws, see what they currently provide for elections. And if the way you currently conduct elections is not consistent with what's set forth in the bylaws, then consider amending your bylaws to incorporate your preferred election system or process. Okay, so typically, yes, that requires an amendment to the bylaws. And typically, yes, that will require a vote of the owners. Okay. Now, unless otherwise provided in your governing documents, a quorum of the members must be established in order to conduct an election and any other business on the date of your election annual meeting. So, unlike condominiums, you don't need a quorum. But with HOAs, really the first agenda item should be to establish quorum. And if you do not achieve quorum at your HOA annual meeting, you essentially cannot proceed with your election. And if that happens, essentially the directors that are seated at the time basically roll over to another year, unless, of course, any director decides to resign. Now, unless otherwise provided in the governing documents, directors are elected by a plurality of the votes cast by eligible voters.
Before the next slide, I'm just going to quickly mention, folks, the reasons I'm answering some questions and not all. I'm only answering questions that do not require an attorney's answer or interpretation. So just keep that in mind. I'm not just ignoring you. Back to you, Kerstin.
All right. So candidate eligibility. All members are eligible to serve on the board unless otherwise disqualified. And the statute provides basically the three main reasons why a candidate would not qualify for board membership. And that is if, for example, a person is delinquent in the payment of any monetary obligation due to the association as of the day that he or she could last nominate himself or herself. If you're delinquent as of that date, that you cannot be listed on the ballot. So typically with HOA elections, unless your documents provide otherwise, the statute says that you have to allow nominations from the floor. So that would be the last date that the candidate can nominate himself or herself. So that's basically the deadline by which any monetary obligation to the association has to be brought current. And monetary obligation can be not only assessments, whether it's regular or your special assessments, but can include any fines, any attorney's fees, costs of collection, certainly any interest and administrative late fees that you're authorized to charge a delinquent owner. Also, a person who has been convicted of a felony in Florida or in any other state in the U.S., they're not eligible to serve on the board unless their civil rights have been restored for at least 5 years as of the date that the candidate seeks election. And then any person who has pending criminal charges for forgery of a ballot envelope or voting certificate, felony theft or embezzlement offense involving association's funds, tampering with physical evidence, and then obstruction of justice. They may not be elected to the board. Other than that, if you have other qualification requirements in your bylaws, and a very common one is that a director has to reside in the community, for example, for a certain period of time. Okay. Typically, those qualification requirements could subject the association to a successful legal challenge because these are not qualification requirements that are in the statute. Okay, so just be aware of that. All right, nominations. So a member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. However, if the election process that's set forth in your governing documents allows candidates to be nominated in advance of the meeting, then the association is not required to allow nominations at the meeting. So again, you're going to have to go back to your bylaws to see what process you're supposed to follow. If you have a process that allows owners to nominate themselves in advance, and typically that would be in the form of owners submitting some kind of notice of intent to run in advance of the meeting. If you have that nomination process set out in your bylaws, then on the date of your annual election meeting, you don't have to take nominations from the floor. But if you don't have that, process of nominating yourself in advance, then you absolutely have to take nominations from the floor on the date of the meeting. You're not required to have an election unless obviously there are more candidates nominated than vacancies exist, right? Now, if you have, if an election is not required because there are either an equal number or fewer qualified candidates than vacancies exist, and if you're not required to take nominations from the floor, then qualified candidates will begin to serve on the board on the date of the annual meeting, regardless of whether quorum is attained. Okay, so for example, if you have a system where candidates can nominate themselves in advance, let's say they can submit a notice of intent to run within a certain time frame. Right, and let's say you have a board of 5 and you've only received nominations or notices of intent to run from 3 candidates for a board of 5. Okay, and you're obviously not required to take nominations on the date of the annual meeting. Then that means that on the date of your annual meeting, those 3 candidates essentially get seated on the board and they can start serving on the board after the date of the annual meeting. So now at that point, if you still have 2 vacancies on the board, the seated directors can then fill those vacancies at some point, after the meeting. Okay, they can appoint those seats. Members have the right to vote for elections in person or by proxy, unless, of course, your documents provide otherwise. So I have seen many bylaws where they expressly say that for elections, you're not allowed to vote by proxy, and that's okay. but you cannot take away the owner's right to vote by proxy if your bylaws don't expressly say that. Okay, so again, default to the election procedure that's set forth in your bylaws. If your governing documents allow you to vote by secret absentee ballot, then the statute says essentially that you have to follow the balloting system that's currently provided for elections. That is that you have to provide what is referred to as an inner and an outer envelope to owners so that the ballot is placed in this blank inner envelope. It's sealed. And then this inner envelope is then placed in a second envelope referred to as the outer envelope. And the outer envelope is going to contain basically, some blank spaces for the owner to identify their name as well as their lot or parcel address, and then a space for them to sign their name. Okay, that is the procedure that you have to follow for secret absentee ballot if your bylaws allow. Now, unless otherwise provided in your bylaws, directors also will serve 1-year term. If you want to, for example, have directors serve a longer term or stagger terms, these you'll have to consider an amendment to your bylaws, okay, to amend the term. Now, any challenge to the election process has to be commenced within 60 days after the election results are announced. And typically, election results are announced on the actual date of the annual election meeting. So you have 60 days from that annual meeting to contest any election process, and there are no exceptions to that. If you are going to contest an election, then you have to do it either by binding arbitration with the Division of Condominium, or you can file a petition in court. Okay. Once your directors are elected, typically you will have what is known as an organizational meeting. It sometimes could either follow your annual meeting right on the same date, or it could be a few days after after you've had your annual meeting. So it all depends, and obviously it also depends on your bylaws. But officers are appointed by the board, and they serve at the pleasure of the board. Okay, now your bylaws will dictate what type of officers you're required to have. Typically, at least a president, vice president, treasurer, and secretary. Now, directors may not vote by proxy or by secret ballot at board meetings, except they can vote by secret ballots when electing officers. Okay, and by secret ballot, I mean you can literally use a Post-it note and write in your preferred candidate for a particular officer position and cast your vote that way. Okay, it doesn't have to be anything formal. There is no prohibition against changing officers midterm. So that means if, for example, the president is not doing a good job and you want to remove that individual from their president position or appoint someone else, well, you can reorganize midterm. Just make sure you have, a duly noticed meeting of the board for purposes of reorganizing officers. Okay. Fraudulent election voting activities. Please be aware that any person who engages in any of the following acts of fraudulent election voting activity commits a first-degree misdemeanor. I'm not going to read them here. Oh, sorry about that. I'm not going to read them here, but they are provided in your slides, and you can go back to them and read them, at your leisure.
And everybody will have the slides, by the way. After you fill out the required evaluation at the end, you submit it. The screen after that will have a link to download the slides, and the video to review will be on the website within a few days. Back to you.
Now, effective July 1st of 2024, each of the following acts constitutes a first-degree misdemeanor. So knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent election voting activity, and then giving any aid to the offender with the intent that that offender avoid or escape detection, arrest, trial, or punishment. Now, in terms of vacancies on the board, and we're not talking about vacancies of directors at the end of their term, which have to be filled by election. These are vacancies that occur on the board, during the term. So unless otherwise provided by the bylaws, any vacancy occurring on the board before the expiration of a term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. So what that means is, let's say you have a board of 5 and everybody has decided to quit for one reason or another, and you only have one director left on that board. So the only thing that single remaining director should be doing at that point is appointing enough seats on the board to at least constitute a quorum so that business can be conducted. Because remember, if you do not have a quorum on the board, you cannot conduct business. Okay. So then that single director will appoint at least 2 other directors to have a quorum to then, be able to operate and function. In the alternative, the board can also hold an election to fill the vacancy, in which case you'll have to do an election in accordance with your bylaws. And then unless otherwise provided in the bylaws, a board member appointed or elected to fill a vacancy occurring on the board before the expiration of the term serves for the unexpired term of the seat being filled. All right, let's switch gears and talk about the board of directors. All right, officers and directors of an association have a fiduciary responsibility to the owners. That means that, among other things, unless the governing documents provide otherwise, the association powers are exercised by the board. So really no single director should be making decisions for the rest of the board members. As previously noted, directors cannot vote by proxy or by secret ballot at board meetings, with the sole exception of when you're electing officers. Now, members of the board may use email to communicate. You just can't cast any votes on association matters via email. Okay, so you can email each other in advance of the meeting as to, things that you will be discussing. You just cannot cast a vote by email. All right, notices of board meetings. So remember, a board meeting is a meeting at which the board votes. Okay. So notices of board meetings have to include the date, the time, location of the meeting, and has to identify all agenda items. Typically, unless your bylaws provide otherwise, notices of board meetings are typically posted only 48 hours in advance, unless, of course, there's an emergency as well. Okay. There are exceptions. If your bylaws don't provide otherwise, then notices of meetings at which you're going to adopt either a special assessment or you're going to adopt a rule concerning lot or parcel use, those meetings have to be noticed at least 14 days in advance. Now remember, if your governing documents provide for longer notice periods, then you default to what your bylaws provide. So if your bylaws require at least 30-day notice of membership meetings, you go with that. Of board meetings, you go with that. Otherwise, it's either going to be a 48-hour notice of a board meeting, unless, of course, you're adopting a special assessment or adopting a rule concerning parcel use, in which case you have to provide 14-day notice. In addition to these notice methods, the association may adopt by rule a procedure for posting notices of board meetings and agendas on association websites or mobile applications. And then any rule adopted must include a requirement that the association send electronic notice to members whose email addresses are included in the official records in the same manner as required for notice of meetings of the members. And then such notices have to include a hyperlink to the website or application in which the meeting notice is posted. Now, again, for those of you that fall in this requirement for communities with 100 or more parcels, by January 1st, you needed to have a website. So if you fall in this requirement, you also have to post notice of any board meeting and agenda, as well as any other documents associated with the meeting on the website. Members also have the right to participate at board meetings, and board meetings, of course, are open to all the members except for two types of meetings. Meetings between the board and its attorney with respect to either proposed or pending litigation. And then meetings held for purposes of discussing personnel matters. Those can be closed. Now, you'll still notice the meeting, so you'll still identify the date, time, location that this meeting is going to be held. You will just include a statement that this is a closed meeting, either to consider personnel matters or a closed meeting with legal counsel. Members have the right to attend meetings as well as the right to speak at any board meeting with reference to designated agenda items. Now, unlike a member's right to speak at members' meeting, there's no statutory prescribed time limitation for a member to speak at board meetings. But remember, with membership meetings, they have the right to speak at least 3 minutes. So, that would be also a reasonable requirement for owner statements at board meetings, that they be allowed to speak at least 3 minutes. An owner can also tape record and videotape any board meetings. And then any board meeting, it must be held at a location accessible to a physically handicapped person if so requested by the physically handicapped individual. Now, in terms of compensation, a director, officer, committee member may not directly receive any salary or compensation from the association for performing duties as a director, except for the following. So we're not talking about a director performing a specific service to the association other than in their capacity as a director or officer. Okay, those will fall under conflict of interest rules, which we'll talk about momentarily. This is for services performed by a director or officer in that capacity. So it cannot be compensated except for the following: participation by such person in a financial benefit accruing to all or significant number of members as a result of actions lawfully taken, reimbursement of out-of-pocket expenses incurred on behalf of the association, recovery of insurance proceeds from an association policy, or any fee or compensation if it is authorized in the governing document or by a vote of the majority of the voting interest, voting in person or by proxy. Okay, those are the only exceptions to the compensation rule. Now, kickbacks. An officer, director, manager cannot solicit, offer to accept, or accept a kickback. And a kickback is defined in the statute as anything or service of value for which consideration has not been provided for an officer, director, or manager's benefit, or the benefit of any immediate family from any persons providing or proposing to provide goods or services to the association. Now, an officer, director, or a manager who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. An officer or director violating this prohibition must also be immediately removed from office, creating a vacancy. However, the statute does say that an officer, director, or manager may accept food to be consumed at a business meeting with a value of less than $25 per individual, as well as any service or goods received in connection with a trade fair or education program. Now, if a director or an officer is charged by information or indictment with any of the following crimes, he or she must be removed from office. Okay, and those include, for example, forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement of association funds, Tampering with physical evidence or destruction or refusal to timely allow inspection or copying of an official record, obstruction of justice, and then any criminal violation under the HOA Act. The board must then fill the vacancy until the end of the period of the suspension or the end of the director's term in office. However, if charges are resolved without a finding of guilt, without acceptance of a plea of guilty, the director or officer must be reinstated for any remainder of his or her term in office. Another ground for removal, a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association is deemed to have abandoned his or her seat on the board, creating a vacancy. So it is an automatic abandonment of their seat if they're more than 90 days delinquent on any monetary obligation. All right, conflicts of interest. A director and officer must disclose to the association any activity that may be reasonably construed to be a conflict of interest at least 14 days before the vote, before the voting on the issue or entering into the contract that is subject to this conflict. Now, what is the conflict of interest? Well, the statute says that there is a rebuttable presumption that a conflict of interest exists if any of these two items occur. If either the director, officer, or relative of the director or officer enters into a contract for goods or services with the association, or the director, officer, or relative of these individuals have or hold some kind of interest in an entity that is looking to enter into a contract with the association. So a good example is, Joe's landscaping service. So if Joe is a director on the board and Joe owns a landscaping company and wants to provide landscaping services to the association, well, that transaction or that contract, there's a rebuttable presumption that a conflict of interest exists. Now, if the association enters or is considering entering into a contract or a transaction with one of its directors or an entity in which this director or officer has an interest, then you have to comply with these items. The statute doesn't say that you're prohibited from entering into a contract with Joe's landscaping company, but you do have to follow these requirements, okay, to avoid that conflict of interest. So the proposed contract with the director has to be fully disclosed to the board, and the disclosure has to be entered in the board minutes at which the contract is being considered, and it requires a vote of 2/3 of the directors present. So it's not a majority of the directors, it's 2/3 of the directors present. The contract or transaction with the director must be reasonable and fair. And then at the next membership meeting, whether it's your annual meeting or a special membership meeting, the contract or transaction with the director has to be disclosed to the membership. And guess what? The membership may vote to cancel that contract or transaction by a majority vote of the members present at the meeting. So the members, while they don't approve the contract, they have the ability to basically vote down or cancel that contract that the board just approved. And if the members cancel the contract, then the association would only be liable for any cost of services or goods received or provided up to the date of termination. You wouldn't be subject to any termination or liquidated damages as a result of this early cancellation of the contract. All right, I think that was about an hour. We are about halfway through, so let's keep going. Again. So in the next few slides, I have identified the official records that the association has to maintain. So these are all the types of records that you have to be maintaining. Not going to go in detail. You can read them on your own, but essentially your financial, accounting records, certainly copies of your governing documents, any documents associated with a member vote, as well as the last bullet point, all other written records of the association that are not specifically identified, which are related to the operation of the association. Now, the official records have to be maintained for 7 years, unless your documents, of course, require a longer period. Bids received by the association for work performed must be kept for 1 year. And the only other exception to the 7-year rule is in this slide, essentially ballots, sign-in sheets, voting proxies, and all other documents associated with an owner vote. Those have to be maintained for at least one year. New laws effective July 1st of 2024, the association must adopt written rules governing the method or policy by which the official records are to be retained and the time period such records must be retained. Okay. Now, there are certain records that are not accessible to owners, and I've identified them here in these 2 slides. Certainly, records protected by attorney-client privilege, any information obtained in connection with the approval of a lease, sale, or other transfer of parcels. So, for example, if your community is one that is allowed to approve or disapprove buyers or tenants, and you have a process where the applicant has to submit an application and you run a background check with all of that, all of those documents, all that information is then remains confidential and cannot be disclosed to the owner or to the applicant. Certain personal information also must be kept confidential. Personnel records, medical records. Medical records might come up, for example, in a situation where the owner is requesting some kind of accommodation or modification and needs to provide some proof of disability and disability-related need for the accommodation or modification. So that's when that would come in. All right. Attorney-client privilege. Just note that also any records protected by attorney-client privilege are confidential. They're not accessible to owners. However, it really is, it's a board decision whether or not you want to waive that privilege. So it's not so much, so the attorney is not the one that can waive privilege. That is only, that can only be done by the board. Okay, so certainly any written communication between counsel and the board is deemed confidential. Membership directories. An association may print and distribute to owners a directory containing the name, lot address, and telephone numbers of each owner. The owner can, however, exclude his or her telephone number from the directory if they request to do so. An owner can also provide written consent to the disclosure of other contact information which is not otherwise accessible. So an owner, for example, can consent to the disclosure of their email address. All right, in terms of access to the official records, if you receive a written request to access official records, you have to make records accessible within 10 business days after receiving an owner's written request. Now, to comply with a records request, the association may have a copy of the records available for inspection, or the association can make the records available electronically via the internet or allow the records to be viewed in an electronic format on the computer screen and then printed upon request. Now, if the owner submits the written request for records by certified mail return receipt requested, and access to these official records is not timely provided within the 10 business days, there is a rebuttable presumption that the association willfully failed to comply. Okay, in which case, if you deny access, The owner is entitled to minimum damages of $50 per calendar day up to 10 days, with the calculation beginning on the 11th business day after receipt of the written request. Okay. Now, another law that took effect July 1st of 2024, if the association receives a subpoena of record for records from a law enforcement, the association now must provide a copy of such records or otherwise make the records available for inspection within 5 business days after receipt of the subpoena, unless otherwise specified by the law enforcement agency or in the subpoena. And you have an obligation now to assist law enforcement agency in its investigation. Some of the changes that took effect July 1st of 2024 also criminalize certain types of conduct relative to inspection requests. So, for example, any director or manager who knowingly, willfully, and repeatedly fails to provide access to the official records with the intent of causing harm to the association commits a second-degree misdemeanor. And the term repeatedly is defined in the statute as meaning at least 2 or more violations in a 12-month period. Okay. The withholding of the records has to, again, be knowingly, willful, and repeatedly. Now, any person who knowingly and intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records with the intent of causing harm to the association, one of its members, commits a first-degree misdemeanor. And then any person who willfully or knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, commits a third-degree felony. Now, the statute does allow the association to adopt reasonable rules regarding the frequency, time, location, and notice of records. However, these rules cannot, for example, require an owner to show any proper purpose for the inspection. So you can't require an owner to identify the reason that they're looking to inspect any record. You also cannot require an owner to state any reason for the inspection, and you also cannot limit the owner's right to inspect records for less than 1 8-hour business day per month. Okay, and that's in the statute. Now, in terms of copying official records, so if an owner submits a request to inspect records and they want copies of these records, they're certainly entitled to receive copies upon payment of proper copying charges. Now, if they show up at the inspection with a portable device like a smartphone, a tablet, a portable scanner, and they start taking pictures or scanning documents, you cannot charge the owner for copies. Okay, they're allowed to do that free of charge. Now, if the association has a photocopy machine available where the records are maintained, then you must provide owners with copies upon request during the inspection if the entire request is limited to no more than 25 pages. You can also charge them 25 cents, up to 25 cents per page for copies that are made on the association photocopier. Now, if you do not have a photocopier, or if the records requested to be copied exceed the 25 pages in length, then the association can have these copies made by an outside source like Kinko's or Office Depot, and you can then charge the actual cost of copying as supported by an invoice from the vendor. Now, the association can also charge for the cost required for personnel to retrieve and copy the records, but only if the time spent retrieving, copying the records exceeds 1/2 hour, and if the personnel costs do not exceed $20 per hour. You cannot charge personnel costs for records requests that result in copying of 25 or fewer pages. All right, let's go quickly to association websites. This should be old news, so I'm not going to go into a lot of detail. But again, January 1st was the deadline by which associations with 100 or more parcels needed to have created website. The statute provides basically what that website or application has to provide. You have to be able to also provide a username and password to owners to be able to access certain information that's not otherwise accessible to the general public. I'll let you read some of these requirements. And then the statute also identifies the types of records that you have to post on your website. It's not the laundry list of the records you have to maintain as part of your official records, but it's some of that, okay? And so here's the list of the records that you have to post. You can review that at your leisure. I think this is some of the stuff that we've already discussed.
I'm going to quickly interject. I have a user, an attendee here with only a first name. Carrie, I need you to respond to me in the chat with your last name if you want to get credit. I just sent you a chat. Back to you, Kerstin.
Yeah. All right, let's quickly move on to amending the governing documents. We do offer a course that is more in detail of how to amend the governing documents, but we've just included here just a few pointers. Essentially, to amend the governing documents, unless your documents provide for a different membership approval requirement, the statute says that you need the approval of 2/3 of the voting interest of the association to amend either the declaration or the bylaws or the articles. The format of amending documents is that you have to identify the changes with either underlines, words that you're adding, and then striking through words that you are deleting. Okay, so that the membership can see what you're changing. Now, if the change is substantial, you have the option of not identifying the changes with underlines and strike throughs, but instead you're going to have to put verbiage at the top of the amendment that's provided here in the second bullet point, which is this is a substantial rewarding. See the governing documents for current text. So you got to do one or the other. Just be aware that there could be a requirement in your governing documents to obtain the consent of certain types of mortgagees. And the statute does provide for a process for obtaining that mortgagee consent. So that's something that you should discuss with legal counsel. Do note that amendments only become effective upon being recorded in the public record. So just because the membership and the board approve them, if they're not recorded in the public records, it's as if it didn't happen. So be sure to record all the amendments. And then the statute does require the association to provide copies of the amendments, of the recorded amendments to the owners within a certain time frame. Okay, so be sure to read this slide if you fall in that category. All right, a few gems, a few topics that also just want to highlight here. Governmental filings. Each year, remember I said your articles of incorporation are filed with the Division of Corporation, right? And so each year you have to basically file an updated annual report with the division, which among other things will identify who are the current directors, officers of the association. Now, the annual report has to be filed within a certain time frame, between January and May of each year, and there is a filing fee, but if you don't file your report in time, you will be subject to a much higher filing fee. You also have your annual income tax filing. Now, yes, you are a corporation that is not for profit, governed under Chapter 617, but you're not exempt from filing annual tax return. Okay, so make sure you get with your accountant for that. All meetings have to, for all meetings, you have to take minutes, whether it's membership, board, or committee meetings. Just note that minutes do not have to be a verbatim record of everything that was discussed at the meeting, right? It should be really just include the date, time, location of the meeting, the motions that were made, who made the motion, who seconded the motion, and then the vote that was taken. If there's a particular issue that is of great importance, I mean, you could include, some record or some transcript of what, some of the points that were raised, but really it should not be a verbatim record of everything that was said at the meeting that could potentially expose the association to liability. In terms of rules adoption, typically rules are adopted by the board, not the membership, although I've seen documents where that require membership approval. So make sure that you do check your documents before you adopt rules. As I had mentioned a few slides ago, if you are going to adopt a rule concerning the parcel use, then you do have to provide 14-day notice of the meeting. Otherwise, if you're just adopting rules regarding use of common areas and facilities, that only requires a 48-hour notice. Marketable Record Title Act. I just want to point out here that your declaration of covenants is essentially good for 30 years. It's not a document that is valid in perpetuity, okay? It has an expiration date, which is 30 years, typically from the recording of your original declaration. If you're getting closer to that 30-year mark, there are steps that you need to take. It is a business, it's a fiduciary obligation of the board to make sure that you preserve your declaration before it expires. And there are certain ways that you can preserve your declaration. And all of it really requires some form of recording in the public records. So if you're approaching that time frame, be sure that you get together with legal counsel on that, okay? Certainly we've assisted many clients in that preservation process, which typically only involves a board vote. So you don't need any membership vote to preserve existing documents before they expire. Now, if you've let your documents expire, then that's not good. There is a process to revive or revitalize those documents, but that is typically a more expensive process, and it is a process that requires membership approval, as well as requires the approval of the Department of Commerce in Tallahassee. So it's a much more involved process. As well as you subject the board to potential claim of breach of fiduciary duty. Okay, so check your documents, make sure you have it calendared as to when they're about to expire, and then make sure you take action to preserve them.
One more last interruption. There's a person named Jill in the attendee column. Jill, I need your last name. Please put it in the chat. Back to you, Kerstin.
Thanks, Jeff. All right, emergency powers. Not really part of the HOA board certification class requirement, but we've added some slides for you just to be aware of some of your emergency powers in case of a hurricane or other emergency. So do encourage you to read these at your leisure when you get the slides. Litigation authority. Again, the association is an entity that has the ability to sue and, of course, be sued. Just be aware that before you commence any litigation here in the last bullet point, before commencing litigation against any party in the name of the association involving amounts in controversy in excess of 100,000, the association must obtain the affirmative approval of a majority of the voting interest at a meeting at which a quorum is established. Okay, just wanted to point that out. All right, architectural control. A lot of these restrictions went into effect July 1st of 2024. Just wanted to point out some of that. All right, effective July 1st of 2024, the association has to reasonably and equitably apply and enforce all your architectural and construction improvement standards. Okay. And if you deny an owner's request for an architectural change, you now have to provide written notice to the owner stating with specificity the rule or the covenant on which the association relied upon, as well as the specific aspect of the proposed improvement that does not conform with the covenants. Okay, so if an owner is looking to install a new door or windows or a new roof or paint the exterior of their home, and they are required to submit some architectural form to the board or a committee for approval, these are the steps that you have to follow this step if you end up denying the request. Okay, so it's no longer good enough for you to just check off your application form at the bottom that says denied. You actually have to give the reasons why you're denying the application, the source of your authority, and the part of the improvement that does not conform with specifications, which means that if you do have the authority to control, certain exterior improvements to a parcel, make sure that you adopt specifications and standards. So if, for example, an owner wants to replace the roof or wants to paint the exterior of their home, make sure that you have, specifications for the type of roofs that are permitted to be installed, as well as, color wheel selection that you will allow in the community. Because if you don't have a set of specifications or standards in place, then it'll become difficult for you to disapprove a request down the road. Oh, did I skip a slide? Okay. Effective July 1st, an associate of 2024, an association cannot enforce or adopt a covenant or rule or a guideline that limits or places requirements on the interior of the structure that is not visible from the parcel's frontage or adjacent parcel and adjacent common area or community golf course. Okay, so if an owner is only doing improvements or work within the home and you can't see it from all these locations, you cannot require them to get board approval, which for single family lots, that's not a big deal. But if you're an HOA that consists of, townhomes or attached parcels, then this could be potentially problematic. You also cannot enforce or adopt any covenant or rule that requires the review and approval of plans or specifications for a central air conditioning, refrigeration, heating, or ventilation system if the system is not visible from the parcel's frontage, adjacent parcel, common area, or community golf course. And it's substantially similar to a system that has been approved by the association in the past. Also, this section of the statute has been in existence for a few years now, but there were slight modifications last year that took effect July 1st of 24, and that's the language in blue. So essentially, regardless of any covenants, restrictions, bylaws, rules, or requirements, an association, unless prohibited by general law or ordinance, you cannot restrict an owner from installing, displaying, or storing any item on the parcel that is not visible from the frontage, adjacent parcel, or an adjacent common area, community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. Now, effective July 1st of 2024, all associations have to adopt hurricane protection specifications for any structural improvement on a parcel governed by the association. So this applies to all HOA associations in the state of Florida, regardless of when you were created or whether or not you have Catholic language. You have to adopt hurricane protection specifications. And hurricane protection is defined to include, without limitation, roofs, certainly hurricane storm shutters, reinforced garage doors, and so forth and so on. So all specifications obviously have to comply with building code. And the association cannot deny an application for the installation or enhancement or replacement of hurricane protection if it conforms to your standards or specifications. Effective July 1st of 2024, the governing documents also cannot prohibit an owner, tenant, guest, or invitee from parking his or her personal vehicle, and that includes a truck, either on the owner's driveway or anywhere else where these individuals have the right to park under your state, county, or municipal ordinances. You also cannot prohibit an owner, tenant, or guest, or invitee from parking his or her work vehicle in the community, regardless of any official insignia or visible designation, which is not otherwise a commercial vehicle as defined in section 320.01, subsection 25 of the Florida statute. So many of you might have a provision in your declaration that specifically says no commercial vehicles can park in the community. Well, the statute now says that unless this vehicle is deemed a commercial vehicle per the statute, and that means, oh, I thought I would include it here, but the definition of a commercial vehicle is essentially one that weighs at least 26,001 pounds. So unless that vehicle weighs 26,001 pounds, okay, even if it says Joe's plumbing truck, you cannot prohibit that vehicle from parking in the community. Now, again, remember we talked about Kaufman. So whether or not these provisions apply to your community, that's an analysis you're going to have to do with legal counsel. Additionally, the governing documents cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker solely because the contractor or worker is not on the preferred vendors list. And you also cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker solely because the contractor or worker does not have a professional or an occupational license. And the association may not require a contractor to present or prove possession of professional or occupational license to be allowed entry into the community. Okay. All right, let's switch gears to budget and reserves. We're almost there, almost there. All right, so our goal is to be done in the next 20 minutes or so. All right, budgets and reserves. For many of you, this is, you're going to be going into budget seasons very soon. All right, you have an obligation to create an annual budget every year, okay, of estimated revenues and expenses for the upcoming fiscal year. Now, your operating budget will have two main components. You will certainly have operating expenses, and you may or may not have reserves, and we'll talk about that momentarily. Now, as a practical tip, monies that are in your operating section of the budget are not restricted for any particular purpose, which means that the board can then use those monies allocated to one operating line item for other purposes as authorized in the governing documents. Okay, so operating funds can be used for bona fide association expenses. Okay. We've identified here on the slide basically some general operating expenses that you can expect to have on your budget, and of course you might have more, but at a minimum you'll have administrative management fees, maintenance, repair of the common areas, certainly taxes, insurance, professional fees if you, for example, have an accountant and legal counsel. All right, reserves. This is the more complicated part. In addition to your operating expenses, your budget may include reserve accounts for capital expenditures and deferred maintenance, which we've identified here. We've provided these definitions. So examples of capital expenditures might include, for example, pavement resurfacing in your community if you own your roads. Certainly repairs, improvements of common areas, such as, pool and clubhouse and your tennis courts. Sidewalk improvements, and you might have other, capital expenditures. But essentially, statutory reserves may be created upon the affirmative approval of a majority of the voting interests of the association. So that means that, what you might call reserves in your budget, but not necessarily constitute statutory reserves as created under the statute. Because the only way that you could create statutory reserves is if the membership approved those reserves. If you have quote unquote reserves on your budget that were not created by the membership, then essentially those are not statutory reserves, but rather basically a contingency, contingency operating funds. Okay, so they're more operating funds, really, which can be used for any bona fide association purpose. If you have established statutory reserves, in other words, if you have any record of a membership vote establishing statutory reserves, then once they're established, okay, they have to be funded, maintained, or waived only in the manner provided in the statute. Okay, which means that those statutory reserves are now specifically reserved for the specific item for which you've allocated those funds and cannot just be used for any alternate purpose. Okay, so just make sure that you understand that distinction. Now, the amount to be reserved will be based on estimating remaining useful life and estimated replacement cost of the expense of the reserve item. So we're talking about statutory reserves, presuming you've established statutory reserves by the membership. This is how you would calculate your reserves. And typically you would do a reserve study by a professional that would come into your community, evaluate your common areas and your association facilities, and then come up with a reserve schedule, right? And the reserve schedule will then include the total estimated useful life of the asset, the remaining useful life of the asset, the estimated replacement cost of these items, and then estimated fund balance as of the beginning of the period for which the budget will be in effect. So your schedule will essentially tell you, for the roof of your clubhouse, this is the estimated useful life of this roof. This is how much life remains on the roof. This is how much money it's going to cost to replace this roof at the end of this useful life. And then this is how much money you have to essentially collect every month for the remaining period to make sure that you have enough funds to replace that roof at the end of that useful life. Now, if you have statutory reserves, then those reserves can only be used for authorized reserve expenses, which means unless their use for alternate purposes has been approved by a majority of the vote of the members at a meeting. So if you've created statutory reserves, for example, for your roof of your clubhouse roof, okay, then you can only use those reserves for that purpose. You cannot then use those reserve funds to, let's say, repave your streets. Okay, but again, this only applies if you have your membership has created statutory reserves. There is an option to pool reserve accounts, which essentially by pooling, you create an account whereby you put reserve funds for 2 or more items. So let's say you can create a reserve pool for your roof replacement and your pavement resurfacing, or for any other additional reserve items. And the flexibility or the benefit of having a pooled reserve account is that you can then use reserve funds in the pool for any item that's within the pool without having to obtain membership approval. Now, if you're going to be using any monies that's in this reserve pool for items other than what's in the pool, then you will have to obtain membership approval. The other thing about having statutory reserves is once you've created them is that you have to fully fund them every year based on your reserve schedule. Now, the statute does allow associations to give owners the option to waive or only partially fund those reserves every year. Now, whether or not you want to give owners that option, it's a business decision. Okay, but it does require a membership vote to either waive or only partially fund those statutory reserves. You also have the option to terminate those statutory reserves, but it will require a vote of the owners. So it'll require a vote of the majority of the total voting interest. Okay. In terms of adopting a budget, unless your documents provide otherwise, really, it only requires notice of the meeting at which you're going to adopt a budget to be posted 48 hours in advance. Okay, but if your bylaws provide for a different time period, or if your bylaws require you to provide a copy of the proposed budget to the owners, then you go with that. Otherwise, there is no requirement in the statute for you to provide a proposed copy of the budget to the owners in advance of adoption. Now, after your budget has been adopted, the association has to provide each member with a copy of the budget or notice that a copy will be made available upon request at no charge. And then if requested, the copy of the budget must be provided to the members within the time frame set forth for the inspection of association records, which is within 10 business days after receiving the written request. And then, of course, for those of you who fall within the website requirement, now you have a duty to also post a copy of the budget on your website. All right, assessments and foreclosures. So with regard to special assessments, just be aware that if the board is looking to adopt a special assessment, unless your bylaws provide for a greater time period, you have to provide notice of the meeting at which you're going to adopt a special assessment at least 14 days prior to the meeting. And of course, that notice can be mailed, delivered, or electronically transmitted. Now, that notice does have to include a statement that a special assessment will be considered, the nature of the assessment, and then it should identify the estimated cost of the assessment. And then once the board adopts the special assessment, you should send notice to each owner, letting them know of the adoption of the assessment, and then as well as how much they will owe, and then obviously give them a reasonable opportunity to pay back that special assessment. Now, effective July 1st of 2024, there is this new requirement in the statute that now provides that if an owner makes a written request to the board for a detailed accounting of any amounts he or she owes to the association, the board must provide such information within 10 business days of receiving the request. Now, the owner is limited to only making this request for accounting at least once every 90 days. And the failure of the board to respond within 15 business days to a written request for accounting constitutes a complete waiver of any outstanding fines of the person who requested such accounting, which is more than 30 days past due and for which the association has not given prior written notice of the imposition of the fine. Okay. In terms of collection of your assessments, assessments that are not paid when due, they can bear interest, and the interest will be whatever is provided in your declaration or in your bylaws, or if your documents are silent, then it would default to 18%. In terms of late fees, the statute allows associations to charge an administrative late fee not exceeding the greater of $25 or 5% of the amount of the installment. But you can only impose this late fee if your governing documents allow you to do that. Okay. And then certainly the statute provides for entitlement to collect attorney's fees and costs incurred in collection. Do note that if an owner is delinquent and they make a payment to the association, the payment has to be applied in accordance with the statute, which means Any payment received by the association must be applied first to interest accrued, then to any administrative late fees, provided that you're authorized to charge those fees, then to any costs, and then reasonable attorney's fees. Okay, and then lastly to the delinquent assessment. Also note the requirement to provide a notice of late assessment. So under current law, if an owner is delinquent, before you turn over the delinquent account to your legal counsel for collections, you have to provide owner with what is known as a notice of late assessment, or NOLA, essentially giving the owner an opportunity to pay the delinquent amount within 30 days. So you'll identify what the assessments or what the delinquent amount is, any late fees that have incurred, any interest, and you're going to give them 30 days to pay. And if they don't pay, then you can refer the account to your attorney for collections. If you don't send out that NOLA, right, and you proceed with collections with legal counsel, then the consequence of that is that you will not be entitled to collect attorney's fees. Okay, so you want to make sure you or your management firm sends this NOLA before you turn over your delinquent account to collections. There are also 2 additional statutory notices that need to be provided to an owner before you can even foreclose on a delinquent account. And those are your notice of intent to lien. So you have to give owners at least 45-day notice of the intent to file a claim of lien against the property if they don't pay. And then if the owner doesn't pay within the 45-day time frame, then you have to provide the owners with another notice of intent to foreclose. And if they then don't pay the delinquency within those additional 45 days, then the association can proceed to foreclose. Note that the liability of a first mortgagee that takes title to a parcel through their own foreclosure procedure is the lesser of either the 12 months of unpaid assessments or 1% of the original mortgage debt. So whichever is less. All right, just want to quickly mention here the financial reporting requirements. Each year, the association, in addition to the budget, has to prepare a financial report of your preceding year's financial activities, and that has to be done within 90 days of the end of the fiscal year, or annually on the date provided in the bylaws. And typically, you will have your accountant prepare this financial report. Then within 21 days of the financial report being completed, and certainly no later than 120 days after the end of the fiscal year or as provided in your bylaws, the board has to provide each member with a copy of the financial report or a written notice letting them know, hey, the financial report is completed and will be made available to you free of charge upon request. Okay. Now, the level of financial reporting, unless your bylaws specifically require you to do an audit, your level of financial reporting will be based on the total avenue revenue of the association. And the statute identifies those dollar thresholds. So for example, if you're an association that has a budget of at least, an annual revenue of at least 300,000, but less than 500,000, then per the statute, you're only required to prepare reviewed financial statements. Okay. If your annual revenue is $500,000 or more, then per the statute, you are required to prepare a financial audit. Now, as of July 1st of 2024, regardless of your total annual revenue, an association with at least 1,000 parcels must prepare financial audit. Okay. Now, the statute does give the option to raise the level of the financial reporting. So if you're by statute only required to do one of the lower levels of financial reporting, and let's say the members want to, or the board wants to do a financial audit, There is an option to do that, but it requires a vote of the membership, a majority of the total voting interest. Okay. There is also the opportunity to do a lower reporting level, and also requires a vote of the majority of the voting interest present at a meeting. Now, if you do end up getting a membership vote to lower the financial reporting requirement for any particular year, do know that the statute currently provides that the association may not prepare financial statement at a lower reporting level for consecutive fiscal years. So if you're required to do a financial audit and you obtain the membership approval to do a lower level of reporting, just note you can't do it for consecutive fiscal years. You're going to have to do the financial audit the following year. My slides seem to be stuck.
Uh-oh. Let me see what page you're on. Let me see if I can get mine on there. You are on page 106.
Oh, okay. Right here.
There you go.
Also note that if you are required to have statutory reserves, there are certain types of disclosures that you have to include in your financial report, basically saying, hey, we're not collecting reserves, and that's if the owners have waived reserves. Hey, we're not collecting reserves, and just be aware that you could be subject to a special assessment. So I'll let you review those. All right, quickly, contracts and bids. The statute does say that contracts must be in writing if the contract cannot be fully performed within a year. Within a year of the purchase or lease of the material equipment, and if it is a service type contract. As a practical matter, really any contract with any vendor should be in writing. Okay. All contracts between the association and really any vendor should certainly identify the costs to be incurred, the scope, the obligation of the party, frequency that each service will be performed, and then the minimum number of personnel to be employed, and should certainly, especially if you're talking about a service contract, make sure you have the ability to terminate. So, my recommendation is always, hey, before you get into a contract, strongly recommend you have your legal counsel review it. All right, bidding requirements. If the cost of the contract is more than 10% of the total annual budget, and that includes any reserves, statutory reserves, then you have to obtain competitive bids. You're not required to obtain the lowest bids. You're not required to obtain bids in case of an emergency. And then any contract that was executed before October 1st of 2004 is not subject to competitive bidding requirements. The following contracts are also exempt from the bidding requirements, certainly with employees, attorneys, accountant, architects, your association community manager, engineer, and then landscape architect. All right, estoppel certificates. Don't want to spend too much time on it, but wanted to at least give you the slides. Estoppel certificates, this will come up if you have an owner that's looking to sell in the community. In which case, typically, you'll know that there's a title company involved, and one of the functions of the title company is to contact the association and confirm, what, if any, assessments are outstanding on the parcel, so that those assessments or any delinquent amounts are paid at the time of closing. So you likely get a request, and it could be from a title company, it could be from a lender. You'll get a request for estoppel information. So this is what this refers to, and the statute addresses these estoppel certificates. So, For example, it requires the association to respond to an estoppel request within 10 business days. The estoppel request must be completed by a board member or an authorized agent. Okay, the estoppel certificates must be provided by hand delivery, regular mail, or by email, and they must be signed by an officer, author, or authorized agent of the association. Now, I've given you here an example of literally what the statute provides for an estoppel certificate. So this is generally the information that you will be providing. There's certain general information about the parcel, and then there's going to be a section all about assessments. Basically, what is the amount of your assessments, the date that your assessments are paid through. Certainly, are there any delinquent assessments on the unit? So you want to make sure you provide this information. The estoppel certificate also requests additional information. For example, is there a capital contribution fee or a transfer fee that needs to be paid in connection with this sale purchase? And those fees you'd only be able to really charge if you have authority in your documents. If your declaration, for example, authorizes association to charge a capital contribution amount on a resale, or if you are allowed to approve, disapprove purchases, and you're allowed to charge an application fee, you'll want to identify that as well. You'll also want to identify any open violations for the parcel, right? Because if the violation has not been addressed by the selling owner, you'll want to make sure that the violation is noted so that the new owner buys with notice and can then address the violation. Okay. If you do not disclose the violation on the estoppel, then you run the risk of waiving the ability to then go after the new owner for that open violation. Okay. Now, the statute also authorizes you to charge for preparation of the estoppel certificate, and I've included the current rates. So, for example, if the owner is not delinquent, you can charge up to $250 to prepare an estoppel certificate. If the owner is delinquent, then you can charge an additional $150 to prepare the certificate. If the certificate is being requested on an expedited basis and you provide a response within 3 business days, well, you can charge an additional $100. Let's see here. The certificates are also good for only a certain period, depending on how you deliver them. So, for example, the estoppel certificates, if it's delivered by hand or by email, those are good for 30 days. And if the estoppel certificates are delivered by mail, they're only good for 35 days. Okay. All right. Covenant enforcement. And I think this is the last section with the time remaining. Okay. So you, as the board members, are charged with the responsibility to uniformly enforce your governing documents and your rules. Okay. So earlier on, we talked about the declaration being the document that contains your use restrictions. And some of your use restrictions might be, for example, architectural. You might have architectural standards in place. You might have pet leasing or parking restrictions. You might have restrictions against certain types of nuisance conduct. So whatever it is, you have to uniformly enforce these restrictions and rules against all owners and residents. Uniformly means, not just against Johnny, but Sally, you don't enforce it against Sally, but only against John. No, you have to enforce it against all residents. And the reason that's important is because if you let certain violations go, the next time that you try to enforce it against a particular owner, they could raise the defense of selective enforcement. Okay. You also want to make sure that you enforce these violations in a timely manner. So typically within a year from the date that you knew or should have known of the violation. If you don't timely enforce it, you also run the risk of the owner potentially raising the defensive waiver. Okay. Now, there are certain remedies that you have in enforcement. Okay. So we'll talk about fining. You have the remedy of suspending use rights, suspending voting rights. You might have a self-help remedy in your governing documents. And then there's always pursuing the remedy of legal action, which may or may not require pre-suit mediation before you pursue litigation. So let's quickly talk about fining and suspension of use rights for covenant and rule violations. So if we're talking about a covenant or rule violation, you have the ability to fine an owner or suspend their use rights to certain facilities and common areas. The important thing here is with a finding and suspension of use rights is that really it's a two-step process. First part is that the board has to adopt the fine and or suspension. And then the second part is once the board duly adopts a fine or suspension at a duly noticed board meeting, the fine or suspension cannot be imposed until the violating owner has had the opportunity to go before a committee, call it a fining committee, suspension committee, or enforcement committee, at least which committee hearing is noticed at least 14 days prior to the committee hearing. And it is at that committee hearing that the committee gets to hear the the violation and makes a determination of whether or not the fine or the suspension can be imposed. Okay, so remember, the board must adopt the fine or suspension first, and then the committee has to essentially ratify the decision of the board. The hearing of the committee must be held within 90 days after issuance of the hearing notice. And the committee has to be composed of at least 3 members who are not officers, directors, employees of the association, or the spouse, parent, child, brother, or sister of the officer, director, or employee. And again, the role of the committee is really not to negotiate the fine or the suspension. It really is a yes or no vote. Either you ratify or deny the imposition of the fine or the committee. And if the committee does not confirm the fine or the suspension, then it cannot be imposed. And then within 7 days after the hearing, the committee has to mail or email a written notice to the violating party of the committee's findings. Okay, including any applicable fines or suspensions that the committee approved or rejected. If the violation has been cured before the hearing or in the manner specified in the hearing notice or notice of the committee's findings, then the fine cannot be imposed. If a violation is not cured and the fine levied by the board is approved by the committee by majority vote, then the committee must set a date by which the fine must be paid, which date must be at least 30 days after the delivery of the notice of the committee's findings. If a violation, the fine levied by the board is approved by the committee and the violation is not cured or the fine is not paid per the notice, then the association can charge reasonable attorney's fees and costs. Now, under the statute, a fine cannot exceed $100 per violation. Okay, so as a board, you can adopt fines of less than 100, but it cannot exceed 100 per violation. And it may not exceed 1,000 per violation in the aggregate unless otherwise provided in the document. So if, for example, you prohibit pets in the community, right, and you've already sent this owner a notice to remove a pet, each day that that pet remains on the property is part of that single continuing violation. So you can impose a fine up to a maximum of $1,000 for each day that the pet remains in the property. Now, if your documents authorize you to charge an aggregate fine of more than $1,000, you can certainly do that. Now, a fine of $1,000 or more may become a lien against the property and collected through the lien foreclosure process if your documents allow that. So currently, the statute prohibits any liens for aggregate fines of 1,000 or less. However, if your declaration allows you to fine for 1,000 or more and gives you the authority to recover that as a lien against the unit, then you can pursue it as a special assessment and then proceed with your lien foreclosure process if the owner doesn't pay. Now, in terms of suspension of use rights, a suspension of the right to use the common areas and facilities does not apply to the portion of the common areas used to provide access to utility services and cannot prohibit an owner or tenant of a lot from having vehicular or pedestrian ingress to or egress from the lot, including but not limited to the right to park. So really, suspension of use rights only applies to your common facilities, your clubhouse, your tennis courts, your pool, if, of course, you have the ability to control access to these facilities. So if owners typically require a fob to go in and you are able to deactivate the fob once you've gone through the suspension process, then this could be a viable option for you to address a violation. Just make sure that you know that you can't suspend use rights to these items listed here on the bullet point, right? And certainly can't suspend the right of an owner to park. Now, effective July 1st of 2024, the statute does provide that an association may not levy a fine for these two specific items. You cannot levy a fine for leaving garbage receptacles at the curb or end of the driveway within 24 hours before or after designated garbage collection day. And you cannot levy a fine for leaving holiday decorations or lights on a structure or other improvement on a parcel that's longer than indicated in the documents, unless such decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the parcel owner. Okay. Now, we talked about finding and suspending use rights for violations of your covenants and rules. You also have the ability to suspend an owner's rights to use your common area facilities if the owner is more than 90 days delinquent in any monetary obligation due to the association. Okay. And the suspension of use rights for non-payment only requires a board vote. So a duly noticed board meeting at which you suspend those use rights. You do not have to go through the committee process to ratify that suspension. Now, again, suspension of use rights would not apply to the portion of the common areas used to provide access or utility service, and you cannot prohibit an owner from parking. The suspension for non-payment of a monetary obligation will end upon the full payment of the delinquency. You also have the ability to suspend voting rights if an owner is more than 90 days delinquent in any monetary obligation. Now, the only wrinkle to this, while the statute gives you this authority, case law has come out, which essentially stands for the proposition that in order for you, an association, to suspend voting rights, either you need to have Kaufman language in your declaration, or the declaration has to expressly authorize you to suspend voting rights. If you have neither of these, then you cannot suspend voting rights. So in an abundance of caution, if this is something that you're interested in as a form of a remedy, then you may want to consider amending your declaration to give you this authority to suspend voting rights. Now, if the voting interest is suspended, then it's not counted, then the voting parcel that has been suspended It's not counted towards the total number of voting interests for any purpose, including the number necessary to establish quorum or required to approve an action. So for example, if you are looking to get amendments passed in the community, right, which are potentially controversial, and you have properly suspended the voting rights of, let's say you have a community of 100, and you've suspended the voting rights of 10 owners in your community, then what that means is, let's say the quorum that you needed to establish is 30%. Well, quorum would be based on the 90 owners, not the 100 owners. And then if you need a vote of the majority of the owners to pass this amendment, you would need to obtain the vote of the majority of the 90 owners, not a majority of the 100. Okay, so it could be beneficial in that sense. Now, remember, suspension and fining, these are alternative remedies. So certainly if you don't have the ability to create a committee, or if you don't have the ability to control access to certain facilities, then certainly, fining and suspension of use rights might not necessarily be a viable option for you. That doesn't mean that you don't have other alternatives of enforcement. At that point, your only option might be to pursue the matter through legal action, okay? But before you can file a lawsuit in court to either force the owner to do something or force the owner to refrain from doing something, you might have to go through pre-suit mediation process, right? And that will depend basically on the nature of the of what you're seeking to do. So disputes that are subject to pre-suit mediation requirements would involve, for example, use or changes to the parcel or common areas, certainly amendments to the association documents, meetings of the board, membership meetings, access to official records, and certainly covenant enforcement. Okay, so before you can enforce any covenant, you would have to go through pre-suit mediation. There are also certain disputes that are not subject to pre-suit mediation, which means you can file a lawsuit in court right away. And those would include, for example, collection of assessments, any action to enforce prior mediation settlement, eviction or removal of a tenant, and alleged breach of fiduciary duty, as well as election disputes. So I'm not really going to go into detail about the pre-suit mediation process. This is really something that your legal counsel will typically handle. Just know that you need to send a formal notice of pre-suit mediation to the violating owner, and there's certain timeframes within which the owner has to respond. You have to select a mediator, and then at some point you're going to have to meet in order to mediate the dispute. Okay, now if the owner does not timely respond, or if there's an impasse at mediation, then at that point, essentially, the association can proceed with the lawsuit in court. And then certainly the statute does allow for recovery of attorney's fees as a prevailing party. Now we're almost at the end. I believe that's the last slide. And I
That
do
is.
point out just self-help remedy. Self-help remedy refers to the ability of the association to basically take action on behalf of the owner to remedy a violation. So for example, if the owner has failed to mow their lawn, and you've sent demand letters and the owner has refused to mow their lawn, if you have language in your declaration that allows you to exercise the self-help remedy, that means the association can go onto the owner's lot and then mow the lawn and recover that expense against the owner. Now, there's case law that's come out that essentially provides that if you have the self-help remedy, then you have to at least try to exercise it before you can pursue the violation in court and then get a court order to force the owner essentially to address the violation. Now, self-help remedy is not always the recommended action. There are risks in the association exercising self-help remedy. Certainly, you don't want to be in a confrontational situation with the owner. And there's also risks of liability and damage. And so it's not always recommended. It should be exercised on a case by case basis. But if you do have that provision in your declaration, then you're limited to being able to go to court to pursue the remedy until you've at least exercised self-help remedy. So whether or not you want to have that self-help remedy in your declaration in light of this case law, I think I encourage you to, basically speak with your legal counsel and potentially even amend your deck to remove that provision. Okay, I think that's it. We're at the
Excellent.
end.
Kirsten, I got some big
Whew.
Tampa news. It's kind of sad, actually. All of our attorneys know that I'm a wrestling fan, and they're texting me that Hulk Hogan just died.
Oh my word.
Wow. It's he's got a bar near you. He's got a club near you guys, right? Over in the Tampa area.
I didn't know.
Yeah, I think he's got a like
Did
a
they say it's
karaoke bar or
fine?
something. Wow. So folks, Kirsten's gonna she's got to run. She's got a couple of appointments, but she'll take a couple of questions. She's gonna look at the Q&A right now. And again, only gonna do a couple. There's only time for a couple because we're over the time here. And while she's looking at two or three questions to address, I am going to reiterate that the link for the evaluation is now in the chat. If you haven't already opened the chat, do it now because you won't see what was placed there before you opened it. You have to have it open to begin with. So open the chat right now. In about 30 seconds, I'll place the link in there once again. And after you submit the evaluation, you can go. You're free to go. The required part is over. Just place the link in there again. After Kirsten addresses two or three questions, I know she's got to run for a client meeting. I will remain on and answer questions about the evaluation and help you with that. I'll share my screen and show you how it's done in case you're having any problems. Then I'll show you where to get the slides and everything. So, Kirsten, lots of great feedback, great presentation. Thank you, everybody, for attending. And
Mm,
I know you don't have time for much. You want to do a couple?
yeah. Let's see here. Do HOA meeting agendas sent to members need to also include all bids and documents to be voted on? Or is this requirement only for condos? So as of now, you're referring to the requirement to provide a copy of the contract or bids with notice of the meeting at which you can adopt it. As of now, that's only a condominium requirement. Let's see here.
And for those of you who also work with a board on a condo, that class we're going to have next week. That's the 4 hour one. So don't drink a lot of fluids. If you know what I mean. Kirsten, back to you.
Does the requirement for the community website also apply to a master? That depends if the master is subject to 720. So if the master association is subject to chapter 720, then yes, the community website requirement applies.
Yes, this video will be on the website, kbrlegal.com, under the resources tab. Just give me a couple of business days.
Can a quorum of the membership for voting quorum purposes be less than 10%? I suppose it could. Is it recommended? Probably not. Probably not. That seems to be very low. Let's see here. Not sure what this means. Can we contact a board member? Can we contact a board? Can we contact a board meeting when we have less than a third of the board members, but one of them is on FaceTime? I mean, board members certainly are entitled to appear, virtually. So, and that would constitute a quorum.
And
Uh,
Kirsten, whether it's a condo or an HOA, if any part of a meeting, whether the entire board is present or not, if you're having a simulcast like Zoom, like we're doing now, there has to be a physical location for people to go watch it as well, correct?
Sorry, say that again. I was reading a
No,
question.
I'm sorry. I'm sorry about that. Yeah, there has to be, even if you do a Zoom meeting for the board meeting, there still has to be a physical place for people to go to watch the meeting, correct? Even if it's on Zoom.
Well, that is what the new condo laws currently require. A similar change was not made for HOAs.
Okay.
Yes, we certainly recommend that if you do give owners the option to attend a meeting virtually, that you still have a physical location for that meeting.
Thank you. That question was earlier in the day.
Let's see. Just want to confirm I heard correctly. No need to fill out a proxy for attendance quorum for elections if I voted because the vote counts towards the vote in attendance. Is that correct? Excuse me. So for if the board has instituted electronic voting, then yes, your electronic vote counts towards quorum. Um, how many years allowed for any director, or can they serve forever? There is no limitation, a term limit, in the statute. So presumably, as long as they remain qualified, they can, continue to serve.
One of our students has my my number, just texted me. Sometimes 2 years can feel like forever on the board.
Agreed. Uh, geez, it was stated that an associate of 100, it was stated that an association of 100 plus parcels must have a website. Would a Facebook group qualify? Absolutely not. Go back to my slides when you get them of what the website requirements are. Make sure that you comply with those.
And social media groups for associations are a bad idea. That's
Yeah.
how dirty laundry gets out there.
Let's see here.
Christopher, and everybody asking, when do the certificates come? Within 7 business days, the certificates for everybody who attended in full will be emailed to the address you used when you registered. Keep tabs on your spam, and it'll be coming from seminars@kbrlegal.com. You can put that email address into your contact list, and it'll reduce the possibility of our email with the certificates ending up in your spam folder.
Is there a presumption of conflict of interest if the HOA is entering into a contract with an owner, not a director? Under the current statute, no, there's no presumption of conflict of interest in that particular case. Can a member ask to see bids of a contract? They can certainly make a request to inspect the bids, yes. Okay, let me maybe scroll down to, oh, my word. I could stay here for like another 2 hours just answering these
Well,
questions.
I know you've got somebody in the lobby, so just do a couple more.
Uh,
You can.
uh, okay, let's see.
The important thing is getting everybody certified, which we did.
Oh,
Yeah, it's
geez.
been a rough week. Ozzy Osbourne, Hulk Hogan. Oh my God.
Let's see. Contract.
Yeah. Scott, yeah.
Let's see. We have no committee, so no fines. That's correct. For fining, you need to have a committee. And I know many communities are just, have a hard time finding those impartial individuals to serve in a committee. And so, right, that might not be a viable option for you. Can the board vote via email to approve or deny? The answer is absolutely not. The statute is very clear. You can communicate via email. You cannot vote by email. So if you have voted by email recently, make sure that you ratify that board vote at your next duly noticed meeting. Okay, I think that's it.
Yeah, now you've done quite
Whew.
well, and I know you need to get ready for this next client you have in the lobby. So, Kirsten, wonderful. Any parting words before you head out? Best way to contact you? And I'll
Yes,
remember, folks, I will remain on to go over the evaluation. I'll share my screen for those of you having any issues. So, Kirsten, what you
yes.
got for everybody before
Good
we
luck
go?
reviewing the slides. There are over 100 of them. But we try not to just include, short snippets. So hopefully you'll find these helpful. Thank you so much for spending your morning, afternoon with us. Again, I'm Kerstin Henze, and I can be reached via email, khense@kbrlegal.com, or you can reach me or any of our attorneys. Our main number, 954 928 0680. Thank you so much.